go.
It's 1 o'clock, and so let's call the 18th meeting of the Massachusetts Gaming Commission to order in our new and more cozy quarters. Welcome to all in attendance, and welcome to all who are watching on the video streaming. The chair is on vacation today, and so the four of us will proceed in his absence, and he'll be back for the next, or perhaps the next after that meeting, in any event by August 8. So the first order of business is the minutes of July 17th, with not yet been prepared, so we'll take those up at the next meeting, and we'll proceed directly to the third item on the agenda, which is the administration and the various subtopics under that. The first of those is the Executive Director Search Update. And Mr. Stebbins, perhaps you could
Sure.
bring us up to date on what's happening there.
Absolutely. Our hired search firm, jury staff, has kind of called an initial contact and outreach list of approximately 50 contacts that they have begun to reach out to gauge individuals' interests, as well as collect additional names of folks they should talk to as they initiate this executive director search. No candidate or any interested party information is being shared with the commission at this time. We have had some initial follow-up discussions since our last meeting, when we talked about, and Commissioner McHugh, I think it was your point about creating kind of a selling package I guess as we approach the baseball trading deadline, we're both buyers and sellers. We're looking for candidates, as well as trying to sell Massachusetts is a great place to live and work. We had talked about creating an ad for an industry publication. We got some initial quotes on that. I think, speaking with jury staff last night, we've decided to back away from buying an ad in a publication. Talking with Elaine Driscoll, our Director of Communications, we think there's some free media we can generate out of the announcement of our search, as opposed to buying an ad. The timing for the ad would have put us into, for this publication, would have put us into September, which is a good month plus away. And we weren't sure we were going to get, we kind of agreed upon the fact that there are enough people aware of our commission, the posting of this position, that we think the buzz is already out there, that we really wouldn't benefit from having an ad in an industry publication. But we are going to do some media around the job description, the announcement of the search, obviously the selection of jury staff. We've had additional conversations about online job sites. They recommended a handful of job sites that are specific to the casino industry. I had a chance to look at those sites. I didn't think they were appropriate, just by the nature of the jobs, that they were more inside industry, posting for, a bartender at a casino in Mississippi. I decided that wasn't necessarily the route to go, but certainly to broader, more traditional names like Monster, careerbuilder.com, posting the position up on those websites. We'll obviously be posting the executive director profile and job summary on the state website, as well as our own website. You have in your, since we're bypassing kind of doing an ad, we've talked to them, and Elaine Driscoll has been part of that conversation about creating a PowerPoint piece that a candidate or a prospect could go through, which would give them background on the Gaming Commission, on the commissioners, on the roles and responsibilities, as well as hopefully promote Massachusetts somewhat. So we're going to focus our efforts away from the ad and creating that kind of piece that they can easily email out to a candidate to have them go through and look and gain some more information about the position. In your packet, you do have the executive director profile. We went through some changes on it yesterday. Most of it was kind of eliminating some duplicative language about responsibilities. Janice Riley, our chief of staff, mentioned to me that some of the profile language wasn't clear because it didn't necessarily reflect where we addressing the reporting requirements to the commission as an entity or the commissioners as the five of us. So we tried to make that distinction more clear when we reference the commission as the agency and as the body. We refer to that to the MGC, where it talks about the reporting relationship with respect to the five of us. We identified those as the commissioners. So we went through the whole body of the document and made those changes and some of those updates. So if there are any questions about it, we can talk about the position profile, but hopefully we can have some agreement on this as a final document, and jury staff can begin to share this document and we can get it posted.
Do you think we need a vote on that, or can we just do it by consensus? Has everybody had a chance to read it?
We have,
Yeah.
have had a chance. I did bring up one issue to Commissioner Stebbins, and that is whether or not we want to incorporate the racing-related activities under the gaming executive director or a separate executive director for racing. So those are things, I think, as we discuss our table of organization, what makes the most sense, we can make decisions. I don't know that there's any need to make that decision today. I would like to do a little more work with regard to how other states handle that and the reasons for same before we but I don't think this document needs to be changed in order to make that decision.
Well, but if we're going to, if the executive director is going to be responsible for racing, she ought to know that as the search proceeds, right?
Well, I'm not sure that that would make a difference in those applying for the position. I actually don't think there'll be very many executive directors for gaming that have any racing experience, which is a reason for us to consider a separate executive director for the racing division. But it is something we discussed, and I wanted to bring it up to all the commissioners as a point of interest and something we'll have to take a look at the table of organization and make those decisions.
The piece of the oh, I'm sorry, go ahead.
No, the point in traveling to a racing event over the last couple of days, there are 3 other states that I'm aware of that have folded racing under gaming, and the 2 that were present each had an executive director for gaming and an executive director for racing as part of the one commission. But I did not have a chance to fully scope out the reasons, and if that makes sense for us to look at it from 2 different perspectives.
Just quickly, the reference, where this is referenced is in the second paragraph of the scope. It says the MGC and therefore the executive director shall oversee and be the responsible regulatory authority for all casino and slot-related gaming activities as well as racing-related gambling activities. I mean, my own viewpoint is that is somewhat general and somewhat broad. I mean, it does talk about the commission being the responsible regulatory authority, which we will be. I certainly see a role for the commission executive director to having some responsibility, maybe not direct oversight of the racing piece, but some responsibility within that reporting authority. I think that sentence is broad enough that it does not necessarily define where a director of racing may fit into the org chart, so to speak.
Yeah, I can see that. You're content to leave that there, Commissioner.
Well,
aren't you?
I don't think it will matter in the large scheme of things. I don't think we'll have someone say apply or not apply based on that sentence.
Yes,
And I
but
think that's the key here.
yeah, but some of the qualities we're looking for may, that may, we're a long ways away from that. Not a long ways, but we're away from that. But the qualities we're looking for may depend on that. It's a conversation we need to have. I think that's
I
the
would
point
agree.
that you're.
That
you're
is the
making.
point I made this morning.
Yeah.
I'd like to ask a question and make a point relative to, at least according to one of the most recent work plans of our consultants, one of the tasks that are upcoming relative to the table of organization is very soon as per their work plan.
Right.
So I suspect, and I don't know if this work plan has changed since I last printed it much, I suspect that we'll start to see very soon options of table of organization
Right.
from our consultants, where racing has to be an important component. And could we, table this notion until that, until those discussions of the table of organization, if that is the point that Commissioner Cameron is making.
Yes, that's what I understood it to be. I don't think we can decide that today, but I think that the job description, if we're going to circulate a job description, ought
Yes.
to mention
Yeah.
in the broad way that it does, that there may be some racing responsibility. That can always be pulled back, but it seems to me that as we go out there, it's easier to put it out there and pull it back than it is not to include it when we send out the initial job description.
I agree. That's why I was content
Right.
to leave the language as is,
Okay. Okay.
moving forward.
So is there consensus then? I'm not sure we need a vote. There's consensus that that's the job description that we'll use. We can modify it if necessary later, but that's the job description we'll use for the moment.
Yes.
Okay.
The other piece of this that Commissioner McHugh and I have been involved in is finalizing the interview and selection process, keeping in mind our interest in, as we begin to get further down the road and talking to candidates, and the question will inevitably come up about the confidentiality of their resume, of their application, in case they don't want their current employer to know. The Commissioner and I had a conversation with the Attorney General's office last week about what we saw as what we're formulating as two strategies. One, having one commissioner involved, potentially with the outside assistance of others. The second was with two commissioners being in a formal subcommittee process. But if you want to share your thoughts on
Well, we
PHEs.
both talked to the Attorney General, focused exclusively on the ability to keep confidential the names and materials of those who did not become finalists. Those who become finalists will be subject to a public interview and the like, and they have to be told that at the beginning. That's the appropriate way to do it. So the question is whether having a subcommittee or having a single screener, both of whom would work with the search committee, the outside search committee, would provide greater assurances to those who did not become finalists that their identities and filing materials would be confidential. And based on those conversations, it's clear to me, and I think to Commissioner Stebbins, that both structures provide confidentiality. The subcommittee structure is a little bit more complicated, but it can achieve the same result. And so I don't think should make a decision today on how that works, because I think it's important for the chairman to be here for that as well. But the decision, insofar as confidentiality is concerned, doesn't need to turn on the structure we choose, although it's a little bit more complicated with the subcommittee structure. And that was the takeaway from the Attorney General, who spelled out the ways that we can do it, which were pretty much the ways that we envisioned. between the public records law and the open meeting law. There's a way to do it. And that's important, not because we or anybody else engaged in this kind of a process is trying to keep things from public view for the sake of keeping them from public view, but in order to attract people who may be employed elsewhere. I mean, this is common throughout all of industry. Attract the most qualified people who may be employed elsewhere and may not wish their current employer to know that they're looking elsewhere for a whole variety of sound reasons. Want to have some assurance of confidentiality before they begin the process of applying. And it's important to try, as we must, to get the most qualified person to run this important institution and be the executive director as we start off. So we need to devise a way that will make the most qualified, the most talented applicants feel comfortable taking the risk of applying to us to become our executive director. And that's the context for this. It's a familiar context and one we need to give some considerable attention to. So that, in any event, is a brief report. You can supplement it, Commissioner, if you'd like to, because we both talked with the AG's folks. But that's the essence of where we are and what we're trying to do.
Yeah, I concur with your comments. And what I've relayed to the folks at jury staff has been exactly that. So that anybody who feels the need to send jury staff any of their information to know at this point, because they aren't designated a finalist, that their information at this point can be kept confidential as part of that process. And I think it would go as no surprise to anybody who is going to be a finalist that their information at that point would have some restraints to it, but they definitely need to be interviewed by the full commission in public hearing anyway. So I don't think that's necessarily a surprise, especially if it's anybody who's been in the public sector already.
So I think maybe does either of you commissioners want to take to have a discussion of that now? I was thinking that the next step when the chairman returns might be to draft up basically a little memo describing the procedures under both based on what we already know and what we learned from our conversations, present it here, and then have a discussion of the other considerations. This isn't the only consideration that decides which way we go, but at least it's an important ingredient of that discussion. Commissioner
I have a question, and maybe this could really be addressed in the memo you discuss. Is there any assumption as to a finalist or a finalists being a certain number, a minimum,
I think
either acceptable or assumed?
There's a minimum number of 2. We have to at least have 2, according to our conversation with the Attorney General's office. And I think that, from the statutory sense, it makes sense, and probably from a common sense perspective, it makes sense to have us at least have an option between 2 individuals, if not more, as long as, the finalists are all considered to be on kind of the same level of caliber and experience and professional history.
Okay. Good.
So we'll have a choice among at least 2, and perhaps more.
No, my only comment is that I think the sooner we make this decision, the better, so that we can, so applicants can be clear and make decisions whether or not they want to proceed with the process.
Right. So let's tentatively plan to take this up again when the chair is back and see if we can't finalize it at that time. Okay. Turning from the executive director then to additional hires. Commissioner Zuniga, anything you have to help us with that?
I drafted the job description and got good input relative to a staff attorney that we are contemplating. We have the need to have a lot of work be done in the area of supporting legal research, regulation writing, and the like, and that is drafted. There's a couple of options that we're contemplating from a procurement standpoint, and one of them is to request 3 quotes from some of our pre-qualified firms or other firms who do these, this type of search. And I am in the process of that. I have not obtained the minimum of 3 quotes, but I may have an update on that next meeting.
Okay. We need to, from my personal standpoint, we need to make tracks in that regard.
Yes.
And I know you
I
share
would
that view.
concur, Commissioner.
All right. So we look forward to the next report.
Yes.
If
Yeah,
I may,
did you wanna-
I have an additional hire to discuss,
Oh, I'm
but I
sorry,
would,
yeah.
I would prefer to hold until I report during the my
Sure.
racing report.
Okay. Let's turn then to internal policies. Commissioner, is there anything you want to say about that?
Yes, a little bit. As you know, I distributed for an internal distribution of the draft 6-chapter employee manual. I hope you have an opportunity to see them or review them. We won't take them up for vote today, but it'd be great to contemplate them in a subsequent meeting if we can do that next meeting. And I know there's the chair is on vacation this next week, so it would probably have to be postponed until after. But their Director Glovsky is looking at them. She has some good comments on a couple of chapters that she's reviewed, and we're still in the process of fine-tuning a little bit of that, with the understanding that these type of policies, have an evolution even when they're adopted, and they will never really be final, if you will. But I'm really looking forward to additional comments that Eileen may have.
Okay, and will we expect another draft then, or a red line draft
Yes.
after we incorporate those comments?
Yes.
Good.
Perhaps we should introduce.
Where is Eileen? There she is. Yes, we mentioned that at our last meeting, I think, we announced gladly that Eileen Glovsky had joined us as the Director of Administration. This is her first meeting. We're delighted that you're aboard, Eileen, and already making your presence felt, so it's great to have you with us. Okay, so we'll look forward to a redraft of that with those additional comments.
Yep.
And still, while we're focused on you, Commissioner, anything further on the project management consultant?
No, with the exception that we did execute a contract with our consultants, PMA, the terms and conditions and the Commonwealth Contract Form. They are currently trying to schedule a meeting with our own consultants. And to my knowledge, that has not happened, but is scheduled to happen this coming week. They're in the process of reviewing some of the memos and information that we have received relative to timeline. For example, the advisory to communities relative to our tentative timeline, et cetera, and they are incorporating all of that information.
I did get an email this morning briefly from Kristen Gooch saying that she had some conversations with them, and I think that is, she's optimistic about the ability to upload the materials in the project plan into their plan. So that process has started. There wasn't a lot
Yes.
of detail, so that's
right.
good.
That's right.
And then we'll have an overall project plan. All right, anything else in the area of administration then? So let's then turn to Commissioner Cameron, to you with the Racing Division updates.
Thank you, Commissioner. I have prepared a memo just outlining our next steps with regard to our racing consultants' recommendations to the full commission at our last meeting. And in that memo, I just outline, first of all, I just summarize all of her recommendations, which include convening a stakeholder review of gaps between current status and regulations and the ARCI model rules of racing, with legal counsel, determine any statutory barriers to regulatory reform, and develop plans to address said barriers, develop an RFP to outsource equine testing, develop plans for accreditation of judges and stewards, work with MGC leadership and human resource professionals to develop organizational needs, job descriptions for 2013 racing regulatory staff and contract, labor, and transition plans. It's moving all the employees from the former state racing commissioner, now they're housed at DPL, over to our operation. And also addressing the financial, licensing, and budgetary issues. I feel there's some urgency in moving this process along, which is why I just wanted to put it down in an outline form here and just talk about some of the immediate steps. We have a group of volunteers who seriously have offered to help us with this process. So what I'm talking about here is a working group. Ms. Allman has agreed to facilitate that working group to really, for a timeliness sake and to really understand what needs to be done. She's going to facilitate that working group, provide her leadership so that these best practices become a reality. We're talking about, when we talk about this working group, it's designed to enhance transparency, incorporate creative ideas, and encourage buy-in from all the stakeholders. So as of right now, and this also will be a work in progress, Ms. Allman will facilitate, Dr. Alex Lightbaum will, who is our chief veterinarian, will participate, Mr. Doug O'Donnell, who is the transition coordinator, will participate, Mr. Chip Tuttle, who is the chief operating officer at Suffolk, wanted to personally participate in this working group. Mr. Steve O'Toole, who's the general manager at Plain Ridge Racecourse, will also be participating. And I failed to put down Janice Riley's name, our chief of staff. She also has agreed to participate, and that's from her standpoint of we'll need to house staff and look at that transition, and she's best suited from the commission to address some of those issues. Certainly, I'll be getting reports, and Ms. Allman will be reporting to the full commission when that's necessary. So this is a group we're going to pull together very quickly to start working on the best way to facilitate regulatory change. In addition to the working group, I'm at this time making a recommendation that we post for an executive director of racing. Again, that we'll have to have some discussions whether or not that's a director or an executive director. The term used nationally is executive director of racing. And of course, when we're able to hire that person would immediately be incorporated into the working group. And also, as we talked about, Commissioner McHugh, we talked about that staff attorney. This would be another area where I'd need assistance from that person to look at those model rules and regulations and see how we incorporate them and make changes with the current. So I'll need some legal assistance there. As you all know, I spent the last couple of days up in Saratoga with a Racing Commissioners International group, established some very good contacts, impressed with the professionalism, the knowledge, and at this point, I think because of those contacts, this is a very small group of individuals. I don't think we would need to use our search firm to assist with this search. All of those involved, and there's several racing organizations that we could post, and I think we could get the message out effectively, what we're looking for, without without the assistance of a search firm for this particular position. I would be recommending to handle that as a single commissioner with the assistance of, someone from our staff to assist with some interviews, and certainly the last couple of finalists would come before the full commission. But I see this as an important piece to move on, and when this plan, as we receive the results from our racing consultant and talked about the work that needs to be done, I see this as something that I'm recommending we move on quickly. And so at this point, I'm just bringing that information forward. I would be working on a job description for the individual. I've had conversations with other executive directors from around the country and who have offered to assist me with that process. So that's the memo that's in your package. Secondly,
Well, before you're going to turn now to the specific, is that all that you wanted to present, Commissioner, on that
correct.
topic?
Just where we are moving forward. The one last piece, by the way, one of the recommendations was to have an audit performed, and that has been requested by the state auditor, and the initial process has begun. Preliminary meetings are being scheduled as we speak for that audit.
Okay, I wanted to just open that piece up for some discussion, because there's a lot packed in there, and it's there's some things I think we might profitably talk about. Commissioner?
Yes, I did have one point to make about our current contract with Ms. Allman. Did not originally anticipate facilitation of a working group, even though the activities that she will be doing continue in the venue of this diagnostic phase that we asked her and contracted her to perform. So I suggest and volunteer to provide a rationale memo to this commission by next meeting, by which we would be extending her contract, and I will be bringing that, to this commission for consideration, so that everybody understands that this is not really part of her original task that we are compensating her for.
Just one thought on the on posting for the position. I would suggest even sharing the job posting description for the director of racing with our friends at Jurastaff, not necessarily to have them go out and find us candidates, but as they're going through the executive director search, they may come across somebody whose qualifications might be more closely aligned with the racing director, and keep in mind,
Sure.
and hopefully, find another potential candidate out of that mix.
I guess my comments and thoughts, and I haven't really had a chance to go through this memorandum in the detail that I want to, but my global thoughts at the moment are two, I guess. I would like to, I think this is terrific. I think we need to move. We know we need to make some changes by the end of the year. We know that we need to make changes based on the report by the beginning of the next racing season. But I'd like to have a little bit more of a feel for what this working group, how it's going to interact with the commission as it moves forward. Is it going to create, for example, a plan at a high level for the commission to approve and say, go forward and talk about things at, say, the 50,000-foot level before it gets down into the detail? Is it planning to work in some other fashion? I think that'd be a helpful thing, at least for me to know and to try and get my arms around, because in the end, of course, it's all of us who are responsible for the decisions that it makes. And the second piece is, I think it's really helpful to start out with a description of this director of racing. What's this person going to do? But there's a real question that I have as to whether, and I haven't heard your explanation and your rationale based on the meetings that you went to, but a real question that I have as to whether there ought to be two separate regulatory regimes within the commission. I think initially of the integration of commission functions and the kind of an organization that is not bifurcated, but the value of having a single commission and a single person in charge. And secondly, there is, in the scheme of things, depending on how the licenses are awarded, a close relationship between, potentially at least, between racing and gaming in some potential licensees, so that the separation isn't all that, conceivably, may not all be all that great. I know you've had discussions with people about this, so while it'd be good to get a job description for this person, I would like to think more and hear you talk about more and have us all talk about more the structural integration of this person with the rest of the commission functions. So,
I agree that we need to start to pay attention to our table of organization and really make some decisions on what makes sense. And I would agree with you, Commissioner, that I envision the licensing function having one system that can be used by the racing division as well as all of our gaming licensees. I don't envision having two standalone systems. It makes no sense from a technology standpoint and for a data collection standpoint.
Right.
And I think from a cost standpoint, one system that can be utilized makes a lot of sense. To answer some of your other questions, I think the working group will be, we don't have all those answers, to be honest with you.
No,
I think it'll be a work in progress where they'll have a meeting and really talk about the best way to move forward, and then have an initial report to the commission on the proposed way to do business, and then certainly I envision updates as the work unfolds over the next several months. And I think that the working group will make recommendations. All decisions will be made by the commission. They will be making recommendations as to what they think is the best way to move forward with the regulatory reform.
yeah, and I have no doubt about that, and I wasn't suggesting otherwise, Commissioner. I was just thinking that for the working group's aid and for our aid, conversations at intervals at different levels of specificity would be helpful to prevent the group from taking a path and getting way down into the detail where the commission might want to go in some different direction. Unlikely, but that could happen. But I think we're on the same wavelength.
I do too, and
Yeah.
I think too, that probably for everyone's, clarity's sake is when Ms. Ullman has a chance to have a first meeting and they can really talk through some of
Right.
those issues, they can give us an initial report
Yeah.
to make sure we're all on the same page.
Right. So I think we're all in agreement then. What if anything, is needed today to kick this off? Simply a consensus that this is a way to
I
proceed,
think that
or
would
do you
be,
want to vote?
I
or-
think a consensus as a way to move forward would be sufficient at this time. And the next thing I'll be working on will be that job description. And then we'll be able to take a look at that collectively also.
Okay. Okay. Any other comments on that aspect of it, of the of the racing commission, racing division report? All right.
Okay, next, under racing are two tentative decisions that I am going to brief the commission with regard to findings. Last, on July 22nd, I, on behalf of the commission, held an adjudicatory proceeding. Was the presiding officer in a matter pursuant to an appeal by Ramon Antonio Acevedo Fuentes, the appellant. Formerly a licensed groom, the appellant was ejected from Suffolk Downs in 1995 due to filing a false application as well as a lengthy criminal record. In 2010, this individual was issued a license, which was subsequently suspended for falsification. In other words, he used a fictitious name in obtaining that license in 2010. He appealed that decision to suspend the license. Sergeant Michael Scanlon of the State Police was a witness in this matter, as well as Chief Steward Susan Walsh, and the appellant, Mr. Fuentes, testified on his own behalf. And I'm going to just give you a brief summary of the findings of fact in this matter. As just stated, the previous State Racing Commission did issue a license to this appellant in 2010. It is a fact that in 1983 he was licensed in New Jersey due to infractions. That license was suspended, revoked. In 1995 he was licensed here in Massachusetts. The appellant failed to disclose his New Jersey discipline on his application. To date, that ejection has not been lifted. Let's see. On the application in 2010, he failed to list any of his past history. And in September of 2010, the State Police and the Board of Stewards realized that Ramon Acevedo was in fact Ramon Fuentes. He was suspended on September 4th, 2010. There were details provided about his criminal history, and based on the findings of fact, the conduct did constitute a valid grounds for ejection and suspension. I found on behalf of the Commission undisputed facts that are sufficient to uphold the ejection and the suspension. The appellant tried to argue that he was unaware of the discipline in New Jersey, tried to argue that there were reasons he was using two separate names. I found his testimony to be less than credible. It's from listening to the facts, I think the evidence demonstrated that the reason he used a different name was to avoid the past criminal history and past falsification being revealed. And it's my tentative decision that I'm putting forth now that the 1995 ejection be upheld and the 2010 suspension be upheld at this time. Again, this is the tentative decision, and the appellant will be notified that he has 30 days to seek reconsideration of this tentative decision by filing a written objection, and where to file that, all that information will be provided. But my tentative decision is that we uphold the objection and the license. And as is our procedure moving forward, the time for questions would be at the end of the 30 days.
Right, there's
if in
nothing,
fact.
nothing for us to do today except accept the filing of that recommended
Yes.
action.
The second filing I have is a tentative decision. Again, this was a formal adjudicatory proceeding on June 19th. I was the presiding officer for the commission, and this was a matter...
July 19th.
I'm sorry, July 19th, yes. Thank you, Commissioner. The matter was held pursuant to an appeal by Jacqueline A. Davis, a licensed jockey. The appellant was suspended for 3 calendar days and ruled disqualified from her second-place finish in a race that was held on June 23rd, 2012, based on a Suffolk Downs Board of Stewards ruling that she crowded other horses during the race in violation of commission regulations. The appellant was present during the hearing, not represented by counsel. Also serving as a witness was Chief Steward Susan Walsh. With regard to a finding of fact, the commission has issued the appellant a license to practice as a jockey in the Commonwealth. The appellant did participate in the first race taking place on Saturday, June 23rd. The appellant's horse was in first place at the first turn in the race. As the appellant's horse made the turn, it altered course and came in toward the rail in order to shorten the distance around the track. With regard to application of law, the commission does have the discretion to refuse to grant a license to any applicant or suspend or revoke the license. The stewards have the power to interpret and to decide all questions not specifically covered by them. I'll skip some of this information. It's background information. The law clearly states that the stewards had the power to disqualify in this case. The commission has the jurisdiction to hear this disciplinary matter, and based on the findings of fact, the respondent's conduct constitutes a violation. I found, on behalf of the commission, that the Stewart Walsh, her testimony was credible, consistent with the evidence, actually observed a videotape of the race, able to see it at different speeds in order to see exactly what the steward was referring to when she talked about the violation. The appellant provided testimony that one of the other jockeys could not understand English, making it difficult to understand what his side of the story was with regard to the infraction, and also that the other jockey did not make a claim against her, the appellant, in this matter. Again, on behalf of the commission, I found the steward's testimony to be extremely credible, knowledgeable of the incident, of the infraction, clear evidence of the infraction on video, and it's my recommendation in this tentative decision that we uphold the decision of the Suffolk Down Board of Stewards suspending the jockey's license for 3 calendar days. The days in which the suspension is to be served shall be determined by the stewards. To the extent that the appellant appeals the disqualification of her mount for the race in question, the commission upholds the disqualification. As in all cases, the appellant will be notified in writing of this tentative decision, notified of her rights to seek reconsideration of this tentative decision by filing written objections within 30 days, and will be provided the address in which to do that. So those are the 2 decisions that I'm filing with the full commission today.
All right, Commissioner, thank you. There is nothing further to do except to file those. They're filed, they're officially filed, and the notices of filing will go forth, and the appellants will have the appropriate time to file their objections, and we'll see if they do, and then take them up for a decision at a later date.
Yes.
All right.
And then my last piece of the Racing Division report for this meeting is just a brief synopsis of the new commissioner training that I attended in Saratoga on Monday and Tuesday of this week. Again, I mentioned that this is the Association of Racing Commissioners International who hosted the training. Very knowledgeable professional group. 15 commissioners, new commissioners in attendance at this course from around the country. Comprehensive program on the responsibilities of commissioners, what the organization does, how to use them as a resource. A number of topics were discussed: licensing procedures, legislative, executive, and judicial responsibilities, the rights, licensing rights versus privileges, judicial review and appeals, open public meetings laws were discussed. Had a complete tour of Suffolk Downs, spoke to all of the...
Saratoga?
I'm sorry, Saratoga, Suffolk
Right.
Downs.
Right.
No,
Right.
Saratoga,
Right.
beautiful old racetrack,
Right.
saw both the harness racetrack and the thoroughbred racetrack. Spoke to the stewards, the racing secretary, paddock judges, clerks, visited the jockey rooms, talked to the starters, the veterinarians. Very, very comprehensive program, learned an awful lot, and really had an opportunity to ask a lot of questions with those who have a great deal of subject matter knowledge. So I think that's very beneficial to our responsibilities moving forward. Just wanted to talk a
Were
little bit
there,
about
were
that.
there handout materials, Commissioner?
Yes,
that-
I will
could you
make copies of it
distribute
all
those
for
as
the,
we-
for the rest of
yeah,
the commissioners'
yeah.
sake, yes. Many, many handout materials.
Yeah, that'd be great
So
to have.
I will do that. Spent an awful lot of time on hearings, which will help me
Right.
in my, as my
Right.
responsibilities. The model rules, which we will be, we've made recommendations
Right.
that we will adopt. Spent an
Right.
awful lot of time talking about those rules, so a worthwhile trip
Sounds
on
like
behalf of the commission.
Sounds like a great trip, yeah. And it would be really helpful to us all, I know, to get the printed materials, so we get a little bit of the knowledge that you
Mhm.
got during that trip. It'd be great. Any discussion about any of that? before
I
we
just
move?
have a technical question. The prior decisions, tentative decisions that were filed,
Right.
They will be taken up 30 days after that filing? Is that my understanding correct?
No, not necessarily. The appellants have 30 days to file
That's
materials with the commission. Then we distribute those materials to all the commissioners for review. And then we set a date for them to be resolved by us within a reasonable time. There isn't a time limit on when we do it, but we need to do it promptly as a matter of policy. So the steps are filing. If there's no filing, then the decision can come on the
Stands.
next week, and we simply adopt the decision without objection. If there are filings, we review them, put them on the agenda, decide, let the appellants know that we're going to decide, and then have a discussion and make the decision. So that's the way we'll follow that.
Yep.
Okay. Good. All right, anything further? Great. Let's then turn to item 5 on the agenda, which is the project work plan in its various manifestations. And the first is the consultant status report. And the first item under that is schedule and scope. And Commissioner Zuniga, you had, that really deals with the next phase of at least the gaming consultant. There's a gaming consultant's responsibilities. Perhaps you could just say something briefly about that. There's a parallel course that we have to follow with the legal consultants, but we've started the process with the gaming consultants.
Yes, we have. The way the RFR was written, in which we procured these consultants, we have the ability to extend the contract for the same type of activities that were procured. And given the timeline and the work plan as we have been undergoing it, or with it, I have asked the consultants to provide us with a plan after, for the months subsequent to September 30th, but within this fiscal year, for practical purposes, to budget that those amounts. So they will be providing that more detail in that venue, and I will be reporting on that as we get that information.
All right. They are currently continuing to work on the preparation of regulations and on the master plan, which is part covered by this contract. And
That's
so
correct.
this really deals with what the next phase will be.
That's what,
Yeah.
yes, what the
Yeah.
next phase will be.
Okay.
Some of those tasks will include implementation of certain, especially RFA Phase 1 activities that we decided early on to implement early, for lack of a better term. And so that's hopeful and looking forward to those detailed tasks. So.
All right. Any discussion on that? Any thoughts about that? They've done a terrific job, and they've really been enormous help to all of us in what we're trying to do.
Yes, they have.
All right, the second item under that is mine, and it is a discussion of policies with respect to the regulations. Let me put that in context, if I might, for everybody's understanding, I hope. We're presently working under a schedule that will allow us to have the Phase 1 application out, posted, ready for receipts by mid-October. In order to do that, we have to have in place the regulations that govern the application process. We also have to have in place regulations that deal with some commission structural issues so that we can support the application process once it gets going. And we need to promulgate those regulations before we issue the RFA 1 application. Under the schedule that we've set out, we anticipate having those regulations in the hands of the Secretary of State for publication by the end of September, and they'll be effective by the time, and have to be effective by the time we issue the RFA 1. The consultants, legal and gaming, have been working on draft regulations. The draft is extensive, it's detailed, it is thorough, it is thoughtful, and we are working collaboratively with them on a draft to present to the Commission for approval shortly. As part of that process, a number of policy issues have arisen. Should we take one direction or another in drafting regulations? And it's appropriate at this time to put before the Commission for approval those policy questions that have arisen. Now, there's policy questions and policy questions. Some are at a level of detail, and we'll get a chance to review those in the fashion I'll describe after we finish this general discussion. But some are of a higher level. Do we take one direction or another in drafting these regulations? So in this memorandum that I've distributed to all of you, I've attempted to capture the high-level policy issues that have arisen and that require some Commission decision. I've included my recommendation as to how we should decide those, but I've vetted that recommendation with both the legal and the gaming consultants in a meeting that we had with them, and can say that this is a consensus document. It has their approval and their thought. The next steps after we deal with these, assuming there's approval of these, or assuming there are changes, and I'll convey the changes to them, is to have another working session with them next Wednesday and Thursday, in which we take these recommendations and the drafts that they're busy working on and try and get down to the next level with the thought in mind that we'll have a completed document ready for review by the Commission at the following meeting on August 8th. Now, that may not be possible, quite frankly. This draft is extensive, but at least we can begin that process. That's the target, by the 8th. Our current schedule calls for sending the regulations to the local local government, local government advisory committee by the end of next week. And our initial thought was that we'd send the entire set of regulations to them for their approval. We don't need to do that. We need to advise them of those portions of the regulations that will have an impact on local government. And we are confident that we can draft a document that summarizes those few provisions of these regulations that will have an impact on local government. Most of these regulations will not. The Phase 2 regulations will have a lot more impact on local government, and we'll have to have a much more extensive filing with them. But these will have very little impact on local government. So that's the schedule. It's got a little, it's a little loose, but we're getting close to the end, and this is a significant step in getting us forward. So with that context and background in mind, you have the memorandum. I can go, I should also say that included in the memorandum, in green type, for those of us who have this version of it, are the policy issues that we decided at a public meeting with the gaming consultants 2 weeks ago. And I put those in there just so we'd have a comprehensive list of what decisions we need to make and what decisions we've already made. So now with that sort of windy prologue, I will entertain any way that would be most helpful to go through this memorandum. I can summarize each of these that remain undecided and see if there's any discussion about the recommendation. If you've had a chance to read it, can simply take comments about things that jumped out to you. Which would be preferable?
I know I had a chance to read it, and first of all, Commissioner McHugh, I want to thank you for the amount of work you put into this. It's really apparent how much thought was put into it, and I was impressed with the level of, it's easy to understand and why you made the decisions or the recommendations. Particularly impressed with number 10, the role of the Bureau in making findings. I absolutely have knowledge that there will be many, many issues that will come up along these lines, and to have the forethought to realize that and not clutter the commission's schedule, I think was a really important piece and made a lot of sense to me. Also, adjudicatory proceedings, number 14. I think that makes so much sense also, not to create a separate process, to keep it as close to existing proceedings here in the Commonwealth makes an awful lot of sense. And I in reading all of them, I did not find one in which I disagreed or didn't understand. It was really easily comprehensible, and all of them made a lot of sense to me personally. So I just want to thank you for the effort into doing all of this.
All right. Thank you, Commissioner. It was a joint effort, and we've really, this is another area where we've really benefited from the help of all of our consultants who've done a terrific job on this. Commissioner Zuniga, do you have?
Well, no, I was actually going to mention that it perhaps for the record and the audience might be helpful to just summarize and either agree by consensus or vote, whatever that may be, each of the policy questions, granted the ones that we have not already decided on, for the brevity purposes.
We can easily do that, and so that will give both the audience here and the audience watching us an understanding perhaps of what we're dealing with. I can run through these quite quickly, I think. And the document itself will be part of the meeting file and will be posted and available for everybody to see. The first has to do with financial assistance to host and surrounding communities, and the question is whether the regulations should provide a mechanism for early funding of those communities. The recommendation is that it should, that the regulation should provide for that, and the mechanism for that is that, as we've discussed before, prospective developers who wish to be qualified and participate in the RFA 1 process will be given an opportunity to file pay the application fee of $400,000, even if they wish, no requirement, but if they wish, even before the application is available, accompanied by a certificate saying they know that the regulations haven't been posted, that they'll be governed by the regulations when they're issued. We take the fee, they become an applicant, and then portions of that fee, in accordance with the statute, are available to cities and towns who wish to use it for planning purposes. So that would be the recommendation for that set of regulations. We need to have regulations that embody that. We'll have an opportunity to talk about the specific regulations that implement that policy, but that would be the policy that drives those regulations. So that's the first. Do you want to do one by one, Commissioner?
Just want to clarify, early funding to communities would then be contingent upon receipt by this commission of the application fee?
Right,
Is that
because the application, the funding would come out of the application fee, not out of commission
Not a
funds.
commission funds.
Yeah, and there may have to be some adjustments there as to how we actually allocate those fees and whether how much is available, but that's what would happen, yeah.
I have a quick question, or I welcome some clarification. Number one, the last full sentence at the bottom of page 1. At that point, cities and towns can negotiate with developers over upfront payment of study and negotiation costs. It's a little unclear on the second half. And when those negotiations have resulted in agreement, can apply to the commission for approval of that agreement. That's the agreement, not necessarily relative to the project, but it's an agreement relative to how much money the developer is going to commit and extend to the town,
Right.
That, or the city for their expenses.
Right.
Okay.
This is a recommendation and a set of regulations that arises from the fact that the RFA 1 process contemplates qualifications of potential developers, not projects. So this focuses on the desire of cities and towns who may have been approached by a developer who intends to seek to become qualified, to begin planning and working with the potential developer in contemplation of the Phase 2 process. So that's what this is designed to do, and to capture that application fee money up front, early, and use some of it not only to support the investigation of the RFA 1 application, but also to begin, as the statute contemplates, albeit somewhat later on, to give the cities and towns a hand in funding their own efforts. So that's what that's designed to do.
And clarification on the end of this, or says, in addition, cities and towns can apply to the commission for some portion of the $50,000 that the statute states. The language says no less than $50,000 out of that $400,000 application fee.
That's right.
So is that language to suggest they could come and get some of that no less than $50,000?
Yeah, there's really two ways, and we'll have to think about this as the regulations go forward and come back with something that gives this in more detail. But there are two sections of the statute. One is section 4.7, I believe it is, that talks about cities and towns and developers agreeing on a fee to be paid for planning and negotiation costs, and then coming to the commission for approval of that fee. Then the second is section 15.11 that talks about the commission taking no less than $50,000 out of the application fee and giving it to cities and towns that apply. So there are two routes that people can go under the contemplated regulations, either the direct negotiation in which a number is arrived at and there's an agreement and that's blessed by the commission, or there's an application for a piece of the $400,000 application fee. Now, that's not final, that's a policy, we've got to think that through a little bit more. Will it really work? But that's the policy that we would ask everybody the consultants, to draft a regulation to implement. It may be, as is always the case, that when you actually get down to the nitty-gritty of trying to execute the policy in the form of the operational details, you find some flaws in the policy that have to be rethought, but this is where we are now.
Well, I would agree with your recommendation to provide for that early funding as stated in this summary and abstract, because that's clearly the intent of the statute, and it clearly helps communities, which is the main point of that.
Right, which have been looking for help, and this will begin to help solve those questions. All right. So the second one is termed exhaustion, and it really poses this question. Once we get the commission stood up, and as we get the Bureau stood up, and as we get the various components of the commission functioning, decisions are going to have to be made by the staff people with respect to a whole variety of things. And the question is, should they be empowered to make decisions and make basically final decisions? And if people are dissatisfied with those decisions, they can come to the commission in a form that the regulations contemplate. Or should the staff decisions be simply recommendations to the commission that have no independent force and effect unless the commission blesses them? The recommendation is the former, that the staff decides unhappy people come here, because otherwise we're going to have long afternoons on many items, and this is a way that we have to operate, basically. At least that's the recommendation. Makes sense?
It
as a
does make
general
sense.
proposition? All right.
I agree.
The third one is entitled variance, and this is basically a clause that's common in many regulatory schemes, and it basically says that if the commission, for a good cause shown, decides to do so, or the Bureau, for good cause shown, decides to do so, it may relax, waive, or permit deviations from commission regulations. You can't create a regulatory scheme without that applies to 99, without having it apply to 99% of the cases, and maybe even 99.5. There are going to be occasional cases where something just doesn't work, and you have to have some flexibility so that you can take account of those situations. There are those who argue otherwise, but it seems to me that you have to have that for a workable kind of thing. So this is kind of the grease that lubricates the sound operation of the regulations. It says for those circumstances we can waive the rules and create something that's fair for the circumstances. Make sense?
Yes,
All
it
right.
does.
Political contributions is one that stems from our obligation under section 20, chapter 23K, sections 46 and 47. Section 46 prohibits applicants from making certain kinds of, we'll call them political contributions. One really needs to read the text of the statute, but that's the main thrust of it. And section 47 requires them to report any such contributions, plus other kinds of donations to cities and towns, and gives us the power, and we have, of course, the power to promulgate regulations to enforce that. The recommendation here is that the commission issue a regulation that defines, and those regulations, I should say, apply to applicants. The commission issue a regulation that says that the person becomes an applicant for purposes of those sections of the statute when the initial application fee is filed, and that insofar as reporting is concerned, the reporting obligation begins on November 22, 2011. And we can't go back in time, but we want to know everything that's happened since November 22, 2011. The reason for that is to set a level playing field and ensure that we get the information that applies not only going forward, but from a constant starting date, so that somebody can't delay becoming an applicant for collateral purposes, and so that we have an overview of everybody at the same baseline. The Office of Political and Campaign Financing is going to issue its own regulations. I've talked with their general counsel. Their regulations are simply going to be looking forward and are going to say nothing more than the statute says, basically. But they are of the opinion that they don't occupy the field, that we will not be in conflict with them if we issue these kinds of regulations, and that they are likely to, in their regulations, use our definition of applicant as the trigger for theirs. So this, I think, will create a congruent, harmonious scheme for both areas, and will serve the public interest by illuminating what's going on. Makes sense to
Yes,
everyone?
it does.
I would agree.
Okay. The 5 is the Code of Ethics. We talked before that an enhanced Code of Ethics that the statute requires us to adopt, applicable to us, to the state police who work with us, applicable to the Alcoholic Beverage Control Commission that works with us, and more loosely applicable to the Attorney General's folks that work with us. That will be a separate policy, not part of our regulatory scheme. We'll publish it. It'll be available to everybody. It just won't be embodied in our regulations. The reason for that is that it applies to 3 independent agencies, and it's a little hard to get a set of regulations that we promulgate that's applicable to other agencies. Much easier to work through a code, a common code that we all agree. 6 is qualifications of developers. We agreed that if during the course of the investigation of the qualifications, the Bureau comes across a disqualifying circumstance in its view, it should nevertheless proceed to the end of the investigation rather than stop and give us a snapshot that that person was disqualified. It prevents us having to come back. Number 7 deals with graded qualifications. There was a suggestion at one point that what the Bureau might do is do sort of a Moody's kind of qualification, A++, B, C, D, qualified but D. The recommendation is not to do that. That's really a judgment from underlying facts. We ought to get the facts. We can take those facts into account when evaluating competing proposals of substance, but there's no reason to give somebody a stigma at the outset that may ultimately not be worth anything and that represents somebody else's judgment anyway.
In other words, the graded qualification will be reserved for phase 2, not for the phase 1 qualification.
No, it's broader than
Or
that, Commissioner, really, that the graded qualification probably will never come into play. That
Okay.
we will have the facts in the IEB's report. This person, this entity is got sound this, got sound this, got sound this, but its financing is a little shaky in this area for these reasons. That's the kind of report contemplated. And then, when you get to this phase 2, you'll have that information for that package, and you'll have similar information for the next package,
Okay.
and we'll have facts, not
ratings.
not ratings,
Fair enough.
that we can make judgments on. And ultimately, it's all a balance between a variety of competing factors, and this seems like a better way, just to work with the facts seems like a better way to do it than the rating. Yeah.
Fair enough.
Okay. The next is whether the commission ought to be able to ask for supplemental information after the application is filed. if in the course of the Bureau's investigation, questions arise, should the Bureau be able to go back to the applicant and say, I need more information on topic A, B, C, and D? The recommendation is yes, they ought to have that power. It's inevitable that they're going to need more information. No matter how completely and thoughtfully the applicant fills out the application, there's going to be questions, and the questions need answers, so.
Is it feasible to think that a request for additional information would also have a timeline attached to it?
Yes, the request for information would have a timeline attached to it, and the timeline would be enforceable by the commission through a regulation discussed later on that would allow the commission to say, this is the deadline, and if you don't meet that deadline for the supplemental information, we're either going to proceed without it, we're going to dismiss your application, we're going to, whole range of remedies, so
Okay.
there will be a deadline. And the next one is request for request that applicants provide supplemental information that is not relevant to their application. This is a tricky one, and it was sparked basically by the chairman's discussion at a meeting several meetings ago about the study or studies that we're proposing to do. The applicants potentially may have a wide range of information that would be helpful to have as we're trying to figure out how to, first of all, craft and then populate the database that we use to get these studies started. Some of that information may not, strictly speaking, be relevant to the Phase 1 application. Much of that information would probably be available elsewhere, though the task of getting it would be more onerous from the secondary sources than it would from the applicant. So the question is, should we have a regulation that allows us to ask the applicant for this kind of information? Helpful information to us, information that's not, strictly speaking, relevant to their application. This is a delicate kind of question. But my recommendation is, yes, that we should be able to ask them for that. And then deal, but ensure that they're free to say, no, we don't want to give you that, or we don't have time to give you it, it's too costly, or whatever. And then try to negotiate with them, or simply go elsewhere and accept their answer. But at least we ought to be prepared to, and authorize ourselves to ask for it. And let them know by inclusion of a regulation to that effect that we may be asking them for that. And also letting them know what the commission's position on their saying no is, so that they understand what our alternatives are.
So the recommendation is to put it in regulation,
Yeah.
not being an obligatory or
Right. Right.
response.
Right.
Yep.
That we would not, in most cases, I mean, we might find in further thought that it turned out to be relevant after all, but
Yep.
but in cases where it wasn't relevant, and that would be most of them, because we'll think this through pretty well, we have other, we will talk to them, we'll do that, but we're not going to penalize them for saying no.
Right.
That's the
Fair
point.
enough. That's good.
And that takes the coercive bite out of it.
Yeah, no, I have a strong interest in this number 9, because I think as we go forward and try to anticipate challenges, I think there is, as you pointed out, there's information they may have available that'll help us kind of look into the crystal ball as to the impact of gaming. There's information, I know the chairman has talked about, interest in, the equal opportunity pieces. So, such a request for, your hiring policy, something, again, information we want to glean in advance. I have a sincere interest, and I've talked to our consultants about getting some inventory as to where a resort casino tends to contract for services, and what those services are, and how much money they might expend, because that information, I think, feeds into, the impact that a gaming operator might have on the small businesses in the region. So I think helpful information to have, or at least ask for at this point, but I think to your point, doesn't necessarily penalize them if they don't want to provide that information.
Okay, that would be the thrust of this, and I think it's important to put that up front. Okay. The next one is the role of the Bureau in making findings on violations of the statute or regulations. This is really a subset of a topic we discussed earlier. Should the Bureau have the right the power, I should say, to make final judgments on violations and have the person against whom the finding runs be free to take an appeal to us, or should the Bureau recommend to us that a violation be found because of a certain set of facts that the Bureau has found? And the recommendation is that in all cases, save the RFA 1 and 2 decisions, the actual licensing decisions, the Bureau ought to have the power to make the final decisions, and anybody can appeal to us. With respect to the RFA 1 and 2, which are the big decisions we'll have to make, they make recommendations and we have the hearing and make the decision in the first instance ourselves. But otherwise, the same rationale for the staff discussion we had earlier. We're going to be overrun with things that the Bureau would otherwise decide and would never come to us. People would be happy to live with the results and go on. So that's the way we'd set that up. All right. The finality of deadlines. This too is one we've decided. It's a subset of the variance kind of thing. That we ought to have some flexibility in the deadlines for extraordinary circumstances. Somebody is ill, the freight train can't get here on time, whatever. And we ought to have that flexibility. Withdrawal of applications, we had a discussion about that the last time, and Commissioner, the chairman said we'd come to a tepid conclusion that we ought to give ourselves some authority over when they could withdraw, so we'll draft a tepid regulation to fulfill that mandate. The filing fee question is whether the applicant ought to be required to pay the application fee upon receiving the application or on filing it. This ties into the first topic. Neither. They ought to be permitted to pay the application fee anytime they want after the date we announce, and sign a certification that they understand the consequences of doing so.
Up until the filing.
Up until the filing, yes. The filing, the end of the filing has to be accompanied by the fee, right? Yes, up until the time when they file the fee. Yeah. Adjudicatory proceedings. The question, and you adverted to this, Commissioner Cameron. Should we create our own adjudicatory proceeding regulations, or should we piggyback on those that already exist for many kinds of other organizations? You're already using those in the racing hearings. The recommendation here is to piggyback on existing regulations. The local administrative bar is familiar with them. The courts are familiar with them. The terminology is familiar to both sets. There's no reason really to go out and reinvent that wheel, which is a complex wheel with many spokes. So the recommendation would be to pick on those. The next is, should the regulations provide for pre-application consultations? The answer, the recommendation is yes, but only for the phase 1 and 2 applications at the outset, because otherwise, when we're thinking about thousands of license applications for various things, again, we'll be swamped. There may be categories that arise as we proceed where we do want to permit those kinds of consultations, or we may create some kind of an ombudsman structure to deal with all of them, anybody that wants help. But at least initially, we ought to limit that to phase 1 and 2, and there will be opportunity for that and need for that. So that's the recommendation there. And finally, penultimately anyway, well, no.
One more page.
There's one more page. Should the regulations provide for notice to the public of the identity of the applicants? The recommendation here is yes, it should. And it should also provide for a structure of what's going to happen once the application is filed. And the structure would be that the IEB, the Investigation and Enforcement Bureau, would investigate, that the IEB would write a report that it would file with the commission, that the public portions of that report would be posted and people could comment on it, and then there will be a hearing on the qualification. And we could take the comments, and we could take the things that come up at the hearing, and we'll make our decision. I say the public portions of the IEB report because the statute says that the application is a public document, except for proprietary trade secrets and other sensitive information. That information is not part of the public application, and the investigation of those parts of the application will not be public, and the IEB's report on them, in all likelihood, will not be public, unless it's general enough not to disclose the kinds of things that are protected by the statute. So that's why that caveat about the public portion is there. But that's what that is designed to do. The next one is more narrow. Should the commission request an RFA 1 application at the same time it issues the application form? The answer is yes, provided that we have in place at least a structure that's capable of receiving and processing the responses. So that's another thing to focus into our overall plan of standing up the commission.
Mm-hmm.
And we'll have to incorporate that into the larger plan and the hiring plan so that we have the structure in place by the time we get there. Penultimately now, should the regulations specify that the application expires if the applicant fails to respond in a timely way? Commissioner Stebbins, this was your point. The recommendation is no. There should be no guillotine, in other words, that simply drops when the time expires. But the commission should have the power to say enough is enough. We've waited. Unless you get it to it by X, we're not going to consider it, or your application's done, or whatever. So those are the regulations. There are some open items that we may have to come back and discuss policy on. I think not, but they are investigations, subpoena powers, and penalties, declaratory judgments. We talked about that a little bit at the meeting with the gaming consultants. I think we found a way around that achieves the objective and doesn't really require a policy judgment. And 23 and 24 deal with hearings, and I think our earlier discussion about hearings will take care of that. We may also have to, at some point, consider another set of regulations to figure out, in a phase 1 sense, how we deal with the Tribal Gaming Commission, interact with them if and when that compact is approved, but that's way down the line, and it's too early now to think about that. We need to do a number of preliminary steps to talk to them before we get there. So that's that report. That's and I would welcome affirmation that this is a way to proceed and the way the consultant should continue to draft the regulations. Okay. Let's move then to the next item on the agenda, which is 5B, technical and other assistance to communities, the Ombudsman search update. Is there anything more to report on that?
The position has been posted. It's up on our website. I believe it's going out on the state CEO website as well. We have begun to receive some resumes. Additionally, I forwarded the job description out to a couple of the regional planning agencies where we've had contact with, as well as Mass Development, which is one of the larger state quasi-agencies that deals with real estate development and business financing. My hope is to potentially solicit some help from both Mass Development and one of the planning agencies to maybe help with some initial interviews for the ombudsman position. But you know, I would say we allow another week or two for resumes to come in, and then begin the process of narrowing down some finalists.
All right. That ties into, in a real way, the next two items. We've talked about the protocol for interactions with state agencies and the community advisory. We've talked at several meetings about those, and in fact, we finalized what they ought to say at the last meeting. This is what's before you today is the incorporation of those final discussions. Is there anything further to discuss about the text of either the protocol for interactions with state agencies or the community advisory?
I have two quick questions, I guess, or comments about the protocol. Obviously, the protocol was generated out of our interest to somewhat be mindful of the process, as well as to support our colleagues in state government who didn't want to be besieged by requests, calls for meetings, questions thrown at their staff. And I'm assuming that's kind of the feeling that, you know, two of those key agencies, Mass DOT and EOEA, somewhat asked us to put this protocol together. Hopefully they'll be mindful of the protocol. I fully expect that there are potentially firms, agencies being hired by potential developers who may have long-standing relationships with folks within the permitting agencies. We hope they respect this protocol and go through the appropriate channels, and certainly through our ombudsman when that person comes on. The other still point of interest or concern that I have is the post-license award. Somewhat comfortable with the language to say without needing to contact the ombudsman to pursue all their regulatory parameters. I still think at that stage there is a role for the ombudsman to play, to be an advocate for the commission, an advocate for the developer, to see the regulatory and permitting process through. To essentially help us finish the job and make sure that the project proceeds with the timeline that has been laid out, because we know that there are steps the commission can begin to take if we don't see a project moving to the initiation of construction. And if we're mindful of, I hate to say, be mindful of election dates. 2014 is another gubernatorial election. How does this protocol potentially carry forward with new folks sitting in either regulatory positions or in those secretariats? So my hope is that our ombudsman will continue to play that role all the way through to the finish line. But those are my two areas of concern.
I think that the once the protocol is put in place, I think it's up to the permitting agencies to follow it as it is for us. So, this is designed to help them.
Right.
It's designed to help us. It's designed to make the path a smooth way, but that's a two-way street.
Right.
So I hope that the permitting agencies will do that. And I think there's also a lot more work that has to be done on thinking through the post-license piece of how this is going to work. And some structural work needs to be done, which we can facilitate, I think, in how permit applications are bundled under a 40D type process or something to move this stuff forward so that it doesn't have sequential kinds of permitting requirements that bump into each other because somebody doesn't have the preliminary permit, they can't get the secondary permit or whatever it is. So I think we need to do more
Yeah.
work, and I fully agree with you, with respect to that.
If we were entertaining a manufacturer that was coming here with 2,000 jobs and a $500 million investment, we would want to make sure that their permitting process gets seen all the way through to completion, and I wouldn't make an exception for a
Right.
gaming operator as
Right.
well.
Right.
I have a question as to the expectation relative to the pre-license award, but after somebody has been qualified as an applicant, so that interim, where there would be a number, many meetings, as many meetings as required or needed. Is the expectation that somebody from the commission, or namely the ombudsman, will be at those meetings, some of which may be taking place at the same time?
No, not necessarily, I
just
think, not necessarily,
facilitation.
would be a facilitator, and this is for, some people do know what doors to knock on, and who to see, some don't. Some on the cities and towns side, don't. And so the ombudsman is going to play a field leveling, facilitating role, not necessarily a substantive role. The ombudsman, though, could, and probably would, this is another thing that has to be developed, probably would develop a relationship with the agencies so that he or she could get answers to frequently asked questions and the like, and help people understand what the policies are. And the idea is to facilitate it, not to be a
Not to be
substantive
present or a
player.
shepherd.
Yeah.
Okay.
Now, the reason, so is there any further discussion on either of those? Then can we agree that those are the final policies? And I think, Director Driscoll, that we've already made some, or are prepared to make some public disclosure of their content. Is that right? Yeah, all right. The one thing we have to keep in mind is that we're trying to engage in a procedure where we're ready to take the application fees by early August. We may not have the ombudsman, but this role kicks in as soon as we take the fee. Chairman Crosby has said he'll play this role for the interim necessary to get the ombudsman. That puts a little energy behind our location of an ombudsman, because this is going to be, I think, a significant job if it's done right. And to work best, it's got to be really a full-time job. So I know we're all conscious of that. Okay, anything else in that category? All right, charitable gaming is the next one. We are obliged to, well, let me put this in context briefly, too. You have in your packet a draft memorandum with respect to charitable gaming, a charitable gaming, a report to the legislature. The statute provided that we were to give a report to the legislature by April 1 on charitable gaming in Massachusetts. We were only invented on March 21, so we didn't have time to investigate and report. We sent a letter to the leadership saying we couldn't do it. We'd do it by July 31st. As of July 31st, we are responsible for regulating bazaars, i.e. Monte Carlo and casino nights and casino nights, Las Vegas nights, that are run by charitable organizations whose bazaars are not regulated by people who hold Beano licenses. So we're responsible for regulating a piece of the bazaar operations by charitable gaming authorities, by charitable gaming institutions. And we also said that we would file this report with the legislature by July 31st. This is a draft of that report. And let me just summarize what's in there. And this summary will be less extensive than the last. There are four kinds of charitable gaming in Massachusetts. There's Beano, otherwise known as bingo. There are charitable game tickets. There is the bazaars that I've just described, and there are raffles. Combined, the Beano and the charitable gaming tickets account for about 73% of the gross amount wagered in charitable gaming. The total is $75 million, of which $18 million is retained by the charities. A big chunk of the difference is given back to the wagerers in the form of prizes. The rest goes for expenses and taxes. The lottery historically has regulated Beano and charitable game tickets. It began to regulate them in 1974 or 73, 74. It's been doing it for 30 years. They've got a staff that audits these games. They sell the tickets. They collect the taxes. They're the whole show as far as Beano and charitable gaming tickets are concerned, although the local communities have the right, must vote to allow a Beano game to be held within their borders. Insofar as bazaars are concerned, anybody who has a Beano license can run a Monte Carlo night or a Las Vegas night. And anybody who has a Beano license can also run a raffle. And the lottery regulates those bazaars and those raffles. That's a minor part of their operation, but they regulate them. The bazaars and the raffles that are not overseen by the lottery are overseen by the Attorney General pursuant to her authority over charities, public charities. Both entities have issued regulations dealing with bazaars and raffles. Those regulations are not consistent. They're different regulations. The statutory criteria for who can get a Beano license and who can get a license to run a raffle or a bazaar are different. And the question is whether all of this ought to be consolidated in one entity. I should say in connection with that question that in addition to the upfront regulation, there is for lotteries and bazaars a role for the town clerk to play and a role for the town police chief to play. And then at the end of it all, everybody has to file a report to the lottery and pay taxes to the lottery on the amount that was wagered. 5% of the gross amount wagered on all these things except charitable pull tabs, tickets, is paid in taxes to the lottery. And 10% of the charitable tickets is paid. So the lottery has a central role in this on the front end and the back end. The question is whether this all ought to be consolidated in one entity, and this report recommends that it all be consolidated in the lottery. I've discussed this in a preliminary way, and actually a little bit more than a preliminary way, with the Attorney General and with the lottery folks. And the consensus seems to be that given adequate resources, the lottery is the appropriate destination for this kind of activity. If the commission agrees with that, and today is not the day to agree, I'll explain in a second what the plan is, then the protocol would be to file this report with the legislature, to say in the report, as this report does, that we would propose to draft legislation to effect the consolidation. We'd propose to draft regulations to support the consolidated legislation. We'd propose to have some kind of a campaign to educate town clerks and police chiefs as to the new scheme. And we'd propose to educate the public and have all of this ready to go into effect by the beginning of fiscal year 2014. So that's what this summary of what this report suggests. Now, this is a draft. What I thought might be helpful to do is to say this is a draft that we accept in principle. Let the Attorney General and let the lottery comment on it to see if there's any major flaws. I think there aren't any. I think there aren't any. and then at our next meeting, approve the final and send it off to the legislature. So, open for discussion.
Yep, I have a question of clarification. When, towards the end of page 6.
Yeah.
And at the beginning of page 7 of this
Right.
report, there's mention as to the drafting of the legislation language that you mentioned.
Right.
And therefore, later, the regulations to support that.
Right.
Is the assumption that this commission would be the one drafting both instances, or would that be done in conjunction with the other state offices?
Yeah.
Or the lottery would be drafting regulations? I just want to kind of clarify that.
Right. The lottery, folks at the lottery, folks at the treasurer's office, the folks at the attorney general's office have been really very cooperative in this, in discussing this topic. All us and those other three entities, well, it's two entities really, have really worked closely together to think this through at a high level. And it's my hope and expectation that we continue that collaboration as we move forward. In fact, it seems to me that because it's our obligation to make this report, we, if this approach is approved, would function as the gateway to the legislature for these reforms, but the entity that would wind up doing the regulation would have a major say in what the recommendations look like, in terms of needed resources, in terms of what the structure would look like, in terms of how it would work, so that we would work with them to figure out who takes the laboring oar, but would work collaboratively to get the job done.
Excellent. Well, to your earlier question, I think the recommendation is a sound one, just for practical purposes, given the amount of monies that flow through Beano to the lottery, et cetera, and the other work that we have to do relative to licensing casinos. I'm happy to hear that there seems to be consensus with other agencies that this would be the recommendation, that this would be placed with the lottery. So I would concur with that.
Yeah, I would agree in principle also that housing this in one agency makes a lot of sense.
Mr. Stebbins?
I would agree.
Okay, so let's go forward. Let's correct the typographical error in the very first word of the report, and do other significant things, and get comments from our partners in this, and then have this ready for approval on the next step. Now, Commissioner Zuniga, would there be anything to discuss about the policies if we had a meeting next week? I know we were not planning to have a meeting next week. I'm only thinking about the fact that we said we would get this report to the legislature on July 31st. I'm sure that they'd understand if we sent them another letter saying we'll be a couple days late. But
it's nothing that cannot wait
Yeah.
for this week. We if we wanted to have a discussion, I suppose we could. More time allows us more time to review the rest
yeah,
of
would
the.
be better, wouldn't it?
Would be
Yeah.
better. Yep.
Yeah.
So
I think we'll take this up then at our meeting on this charitable gaming report to the legislature up at our meeting on August 8th, and not have a special meeting to deal with it next week, unless there's disagreement about it.
I mean, my only concern is, and maybe we could make our homework to review the first few chapters of the policy handbook. I would just, I mean, I appreciate all the work that's gone in the charitable gaming report. I would just hate to ask again for another extension, not that it's a huge issue.
Well, we could easily do this. We could have a meeting next Tuesday, the 31st, with a single item on the agenda, approval of this.
Charitable
Be a-
gaming.
Yeah.
Be a 5-minute meeting, and we would have the comments from the other groups by then. We have a single item on the agenda, we approve this, we get it into them on time, and that would be perfectly easy to do.
I would feel good about that. I mean, we asked for one extension, which obviously, as you pointed out, was not anything we were ever gonna be able to meet just by virtue of when we were all appointed and when
Right.
the deadline was. You know, we met the deadline with taking on racing. I'd like to see us meet this deadline.
Yeah, I think there's
Further
something,
suggestion.
I think there's something to that.
Doing one item if
Yeah.
we can.
All right, so let's have a meeting on Tuesday with this as the item, unless there's some significant issues. Can we do that? Yeah, yeah, good, thank you.
They usually reserve the room across the hall for us for the entire day, so we can figure out what time we want to do it.
Okay. So let's plan to do that then next Tuesday, and this will be the single item on the agenda. All right. Finance and budget, Commissioner Zuniga.
Yes, thank you. The budget and finance update is brief. We, as you know, I have submitted a budget to this commission a week ago, I believe, but more than a week ago, the previous meeting, which was on a Tuesday. We are currently working on putting that budget into the object codes of MARS, which is the accounts payable system that will help us track it as we incur in our operations. Yet another one of the tasks that Director Glovsky is really helping us with as she's hitting the ground running here. I am shooting for the meeting that we are contemplating, next full meeting, if you will, of August 8th, to have a budget for approval with resolution of the questions relative to our numbers for our consultants, which are still being in a state of flux. But if anybody has comments about that budget, either now or prior to that meeting, I'd be happy to talk about them or proceed as planned.
Any questions or any comments on that? The plan sounds like a sound one, and the budget was comprehensive. There are a few things that we'll put into place between now and then.
Yes, and I will highlight those changes. They're really just fine tuning some of the numbers. I reconciled with expenditures from the previous fiscal year to make sure that they were not considered there. So it's a minor updates as we have been contemplating them.
Okay. The next item is item 8A, Public Education and Information. The first item on that is A, and is community outreach and responses to requests for information. Commissioner Stebbins, do you want to deal with that?
Sure. As you remember from our last meeting, I talked about my bucket list, how we deal with different types of requests for meetings with the commission, speaking requests, and I at that time had categorized those into meetings that we might have a request to from a host community or a surrounding community. I think somewhat similar to the request that Chairman Crosby had to go down and speak to the folks in the community surrounding Taunton. This second set of requests that come from community or service organizations, chambers of commerce, Rotary clubs that are interested in hearing about the commission's work and our status and how that kind of folds into the Speakers Bureau that Director Driscoll is put together. A fourth category of, I believe I made mention of my experience on the Springfield City Council and how we incorporated kind of a speak out session prior to periodic meetings of the City Council. and then how we invite folks to come and make presentations to us on a wide variety of topics. So in front of you is a memo that kind of capsulizes those four groups. I did not include what I would call statutory hearings or meetings that we're obliged to have that are called for in the legislation, hearings that we have to go out and do in front of a host community, any hearings that we may choose to have to gather commentary and testimony on hearings or regulations that are being proposed. So those are excluded from this. So quickly, the potential host or surrounding community organization request category meeting would include requests or invitations from any public body or community-based organization that is in a potential host or surrounding community. We simply ask that prior to a decision to go out and speak to that group, that their request be as thoughtful and thorough and detailed as possible in terms of what topics and subjects they want to talk to us about. Then we would have the discretion to decide whether to attend such meeting based on the appropriate nature of the request and kind of the status as to where we are in a potential licensing process or regulatory process. The community or service organization request, and by the way, my initial draft of this I shared with Director Driscoll and our Chief of Staff, Janice Riley. I shared it with another commissioner to get some feedback on it. So their commentary is also incorporated into this report. The community or service organization request, again, this is the typical, Kiwanis Club, a professional association, a Chamber of Commerce, a Rotary Club, wants to have a commissioner come and talk to them about activities of the commission, where we stand with respect to licensing, addressing other issues. This folds into the Speakers Bureau that I know Director Driscoll is going to be talking about next. I did incorporate some language that I might have a disagreement with, and that was some respect to a minimum number of attendees in order to have a Speakers Bureau request or this type of request from a community service organization, whether we decide to accept that invitation, and I'll come back to that in a minute. The MGC Public Speak Out session, we have a mission of transparency. We talk about it at every one of our meetings. What I've tried to create or craft here is similar to how the Springfield City Council would have these public speak out sessions. We would set aside usually about a half hour before one of our regular meetings. Any individual interested in coming before the commission to talk to us about an issue, we would ask that they register ahead of the meeting. Our receptionist, I would see, being able to take down their information, name, address, contact, phone, email, as well as what is the topic you want to address. The day of the meeting, again, 30 minutes in advance of when we would normally start our regular business meeting, the chair could call upon those individuals in the order they were registered, come up, speak for 3 minutes about the topic that they wish to address. If they have additional written comments they want to share with us at that time, they're certainly welcome to do that. I did feel it was important to stress that we want the topics to be germane to the activities of the commission, what we're currently considering, the kind of, should we have gaming debate is somewhat over from our perspective. Now we're in the process of implementing the expanded gaming law. We'd really urge the speakers to address their comments to those issues. And again, an individual would not necessarily expect that a discussion would then kind of ensue between the commissioner or the commissioners. And the fourth group is kind of the MGC, our weekly meeting, again, giving us flexibility at our discretion to bring in officials, academics, experts to address any variety of topics that could impact our work at the time. just to go back to the community service or organization request with respect to what would probably fall into the Speakers Bureau discussion. We talked about having a minimum audience of 30 attendees in order to accept an invitation. I can tell you from my own experience in the Kiwanis Club, I used to, I guess I still am a member, we would never have 30 attendees at a meeting. And I just think if we get invites from these types of clubs and surrounding communities, wherever they may be, they may not be able to meet that attendance requirement. I'd rather give us some flexibility to accept that invitation, but the group would have to recognize that it would probably most, fit in with our schedule with a little bit more than their schedule. But I wouldn't want to rule out that group just for having a minimum attendance number. But I put this up to you, and, if, again, kind of the public speak out piece is a piece that hopefully the commission would agree to begin to organize at future meetings, but I think everything else is more of a policy direction for the commission to take as we handle these types of invitations that we know we're going to keep coming in.
Question, Commissioner, on the public speak out session, since you are familiar with this process, did Springfield City Council have any way of, when you explain to an individual that they have 3 minutes, is there any way of holding them to a reasonable time frame?
The president of our city council had a gavel and would gavel you off.
A gavel.
Got,
I can ask the judge
I have a
to bring
gavel
his
here.
up. I'm
we'll
sure
have
a
the
gavel?
judge bring his in.
I have a-
But we ask people to be mindful of what the rules are of the public speak out, and we would, in this case, direct the chair to cut that individual off.
I have a question on the 30 attendee number. Please refresh my memory. This is from the Ethics Commission notion of, from the ethics laws notion of undue privilege to small groups. Is that sort of the idea behind a group of 30? Or where does the number come from?
I'm going to engage Director Driscoll on this question because this folds into the creation of the Speakers Bureau.
Okay.
Yeah,
as
so
well.
basically after just auditing a number of other speakers bureaus and from various different types of agencies, and then also speaking to other voting control agencies that have speakers bureaus, the number 30 happened to be the most routine one. So in terms of Rotary clubs or Lion clubs that maybe are smaller, many of speakers bureaus have language in there that they suggest that they actually join with the closest one. And so if there's one that's, because that's the other thing I'm finding is that Lions clubs and whatnot, there's many of them all in the same area. So to the extent that, and they have connections, so to the extent that they can join one another for a night to make that number. And I think too, we can address that as we go further. In other words, I'd like to see what the level of request is, and what's manageable for us. And if we find that, casting a wider net and not being as strict about number of requirements is feasible, then I think that's fine. But I think to start, until we have a sense of whether or not we're going to be inundated with requests, keeping it to 30 is a way to manage it right out of the gate.
Fair enough.
And I appreciate that flexibility, and, I think I shared with Director Driscoll, we may get a request that maybe doesn't meet that guideline, but all of us may collectively be out on the road at other meetings and maybe looking for, okay, we know we have a request in that general area, of a chance to stop by and talk to that Rotary Club to kind of fill the schedule. So I think just, I like the idea of using it as a starting point, but again, continuing to give us flexibility, because these aren't groups that we want to leave out, and
Yeah, and I think
putting the onus back on them to say, come together with a couple of your
Right.
brother or sister organizations to make it work.
I think this is a good policy. I know you're going to talk a little bit about the Speakers Bureau in just a second. The host or surrounding community organization request looks restrictive in an area where we're trying to reach out, but I think it's an important and thoughtful way of dealing with this, because we're going to be in a number of areas dealing with competing cities and towns conceivably, and we've got to be in a position to ensure that we are keeping to a level playing field. So we've got to know what it is we're being asked to talk about before we go talk about them. And in order to be effective, we've got to have some list of what the agenda is so we can think through what the questions are. And we've got to be able to decide whether it's appropriate to take up that topic at that time with this town as we go forward. So I think this is a great balance between our desire to reach out, and we need to reach out, and our need to maintain control over the agendas and the topics that we discuss and when we discuss them and how we discuss them. So I think that's a little bit of context for that, and I think it's a great way of dealing with it. The one area that isn't addressed is one that we actually did talk about a little bit, and that is what do we do about people who are in some way affiliated with potential developers who want to come and talk to us. We've bumped into that issue before. Is that completely separate from this? Have we not? I guess I'll put a question mark right there. Is that completely separate from this?
It is separate from this, and you know, I decided not to address that quite yet, only because I think the ombudsman has a piece of that kind of request, or
Good
an
point.
involvement
Good
in
point.
that type of request coming in.
Right. So we get the ombudsman up and running, and then try and filter those kinds of things to the ombudsman and see if we can develop a policy in that way. Yeah, that's good.
Although, and I'm not disagreeing with that notion, there would seemingly be room in the public speak out session for that opportunity. If we are in a public meeting where the topic
Sure.
is previously that somebody can register in advance because they want to speak or submit commentary to this commission, that would be a logical venue.
Another
Yep.
avenue for them to use.
Yes.
Yep.
Their 3 minutes are equally valuable.
Equally valuable to
Right.
everybody.
Yeah. All right. So, let's, do we need some action on this? Perhaps we ought to get Director Driscoll's report and then consider the two things together, because they really are interlocked.
Sure, so basically, a lot of the information in the memo that I've prepared is also in Commissioner Stebbins' memo, but when putting together this sort of list of communication initiatives, it made sense, obviously, to include the Student Bureau portion in this. So basically, like I said, after conducting an audit of numerous other Student Bureaus and various types of agencies, as well as speaking to other gaming regulatory agencies that have successful speakers bureaus, such as Pennsylvania's has a very successful speakers bureau. So their director of communications was very helpful in providing me some feedback on how they do theirs. And again, it all came down to, at the end of the day, these parameters are put in place largely just for management purposes of the program. So a minimum of 30 attendees. Request must be received 30 days in advance. We've already created on our website a request form, essentially, that's very specific. Again, taken from various other organizations that have request forms on their websites that, ask for all the obvious information like name of organization, address, but organization's website, agenda points. Ask them to get very specific about what the expectation should be. Do they provide audio equipment? Yeah, so that's already been created. Brandon Milby helped create that, so all we have to do is push the publish button once we're ready to move forward. I have also, with the help of Commissioner Stebbins and Brandon, pulled together an initial target list of chambers that we wanna, target specifically, just to send out, an advisory that says that this is available if they're interested. So, and then we'll follow up with phone calls as well. So then I had just suggested what the community outreach to raise the visibility of this program should be. I've already put together a press release, with today's points on it, just announcing, you know, additional, community engagement initiatives that we've been putting forward, that to provide the public opportunity to give us feedback. So it would be in that, and then I would do for the Speakers Bureau, another release, and also an email blast to chambers, Rotary groups, Lions clubs, things like that. And again, we would just follow up with periodic email blasts, letting, civic associations know that this is available to them. I've gotten a lot of helpful feedback from the Boston Chamber of Commerce, in terms of some groups that they're suggesting that we make sure that we reach out to. Again, just using our Twitter account and Facebook to make sure we're, continually letting people know. And soon, I'm getting far along in the process with finding, a company that will create the logo, website, brochure, and all that. We're getting much further in the process. I'm hoping that by the end of next week, we'll make a decision as to how we'll narrow it down. Maybe we need to put together a subcommittee to maybe choose the final 3, because right now I have about 5, maybe ultimately 6 proposals in for, logo development and website development. I'd like to narrow that down to 3, and then maybe put a subcommittee together. So however commissioners would like to see us do that, but I would like them, whoever that company is, to start working second week in August, so that by September, we have logo, brochures, at least a couple of pages of a new website, PowerPoint template, so that when we go on the Speakers Bureau, circuit, we have something to present, which will also include brochures, like, so it has one look and feel, and all the information's in one place.
Sounds terrific, yeah. Then you can order the T-shirts, too.
Yes.
Yeah.
Golf shirts.
Golf shirts, I'm sorry. All right, do we need a vote on anything here, Commissioner?
I mean, my simple suggestion would be, you know, if we agree to the, kind of the meeting request criteria, the public speak out criteria, and Director Driscoll's plan for the, you know, the Speakers Bureau, we just give it some type of endorsement or
By
set
consensus,
forth and
we,
use it.
it'd be consensus, we move
agree.
forward.
And I have a couple, sorry, actually, another thing you wanted, for the speak out, do you think that we should be creating, again, on the website, a place where not just from the Speakers Bureau, but names, addresses, email address, like just a place where if you are requesting your 3 minutes, you're very specific about what the discussion will be and purpose?
You know, my initial thought was, you know, they would call our general number and the receptionist could take that information down, just to kind of keep track, but, you know, she can also monitor a place to do that on the website, so that's fine.
Yeah, I mean, my preference would be that there's some sort of paper trail, documented paper trail on it, and I think, and then this way it would put also less onus on a receptionist for vetting, which could potentially get complex.
And a paper trail also helps to bring down the curtain on the 3 minutes if we start veering off the stated subject.
Right.
Yeah.
And then in terms of, where it says expert, visits to the meetings, what should the mechanism be for that?
That's, I leave that at the, you know, is we get letters of interest or run into folks who introduce themselves to us. I think that's really up to the discretion of the commission if we invite somebody to provide that expert testimony. So it's not anybody registering to offer expert testimony.
Okay.
It's us deciding, we have somebody who's a good person, qualified enough to come in and talk to the whole body as opposed to one or two of us exclusively to offer testimony with respect to where we are in the process or whatever our activities are.
Great.
Okay, that's all sounds great. Any further discussion on any of that? Okay. The Western Massachusetts Forum now is taken a really concrete shape. Commissioner Stebbins, you want to?
Sure, just an update. Again, it's going to be August 8th, which is a Wednesday, so I think actually our next regular meeting will be August 7th. I know
August
that
7th,
date
that's
was
right.
kind of
Yeah,
thrown
I
around.
did mention August 8th. Yeah.
So we will be out at Western New England University. We are being co-hosted by an institute at the law school, the Institute for, I think it's Legislative and Governmental Policy. We have two members of the state senate that are going to be talking to us, Gail Canderas, who is the chair of one of the committees that we actually report to, as well as Senator Rosenberg, who was an instrumental architect in the gaming
Right.
bill. This forum is a little bit different because we will be addressing three topics as opposed to one, like we've conducted in our past forums. We will be zeroing in a little bit more on the community mitigation discussion. We will also be talking about tourism, because tourism and the impact of casino gaming on tourism is highlighted and prioritized in the legislation. And then having additional discussion about workforce development and job training. As we, again, I think want to fight the fear of a huge importation of new workers. As it was described to Commissioner Zuniga and I yesterday by Senator Canderas, this really is a jobs bill and making sure that Massachusetts residents have opportunities for the jobs that are going to become available. So we'll hit those three topics at the end. Again, we'll have our usual open session to talk amongst ourselves as well as gather any additional commentary. And then I think this will be our last educational forum as we've been organizing these as we get ready to kind of jumpstart the licensing process. But doesn't preclude us from some of the other scenarios we heard to get additional expert
Right.
testimony.
Right. Yeah, this is going to be another good one, and it's good that we're going to do it out there as well, so that's good. Okay, look forward to it. Any other comments on that? Good, all right. The ninth item and final item is the research agenda. Commissioner Stebbins, is there anything you want to alert us to or
I'm
update us? Or
actually
Commissioner
sure
Zuniga?
gonna-
Yeah, I can give a brief update to that. We met with the Inspector General, not Greg Sullivan, but some of his staff, and to kick around this idea and get a little bit more educated on the notion of entering into an interagency service agreement with UMass for some of the research pieces that we have to do as per the legislation. They suggested something that I think we should contemplate and we can implement in short order, and that is to initiate an RFI process that we can post in our website and make it public with specific mentions or identifying specifically the sections in our legislation that describe the research agenda or the baseline study that we know, and those are sections 71 and 108 among others, and invite the feedback relative to approach from anybody, and hope that UMass, but also other public institutions may respond. That could really inform our approach, and very importantly, it could also inform the best value notion that's behind the regulations on entering into ISAs with sister organizations. So that's an interim process of what we envisioned, perhaps, but one that could really help us in this notion of determining the best value and contracting with another agency, or understanding other options that may be out there. So I will take it upon myself to start drafting some of that request for information language that, again, we can post and we can make available, and we can start getting good responses from people.
This is, obviously, it's so important to what's required of us in the statute, but because we have a requirement in that statute of creating an annual research agenda, that, I think what was unique about our conversation with the Inspector General is that this may not be, a one-year agreement to get the baseline research done, but may actually be a relationship that continues for a few years to come as we go back and reconsider and reassess the baseline information. So it's a little bit different than a short-term service contract with a
Correct.
definitive deadline or a dead window.
But we do have a deadline for the first one, right? Is that the end of 2013?
Yes, 2 years.
November.
Section 108 says in our statute that 2 years after the signature of the act, which was November of 2011, would be the first report to the committees and the legislature, really. And the intelligence is that in order to report on a baseline study at that time, that a lot of work needs to happen prior.
Right. So we have to keep that in mind
We
as
have
we're
to.
trying to get this ramped up quickly.
Mhm.
Right.
Yes.
Right. And we all do, okay.
Yep.
All right. That sounds great. All right. Is there any other business that could not have been reasonably anticipated before we started? All right. And I think we are ready for the motion to adjourn.
I make a motion that we adjourn this meeting.
Is that motion seconded?
Second?
All in favor?
Aye.
Aye.
And the meeting's adjourned. Thank you all very much.